Hello, everyone. My name is Andrew Hall. I am senior counsel with the Blake Law Firm, and I'm here to tell you or talk to you about the ABCs of lease guarantees today. So, a common scenario we see where lease guarantees become necessary are from a landlord's perspective. A landlord has found a tenant that is willing and able to rent on the landlord's terms, but the tenant has no established credit history. So, one prime example would be a new business, for example. From a tenant perspective, a tenant's challenge is that a tenant could be struggling with rent due to a prior lease, and they need to reassure the prospective landlord of the ability to pay rent and carry out the terms and obligations of the lease. So the solution to this type of scenario would be a lease guarantee. First, what is a lease guarantee? Well, a lease guarantee is an agreement between a landlord and a third party, often called the guarantor. The guarantor assumes responsibility if the tenant defaults under the terms of the lease. This could be either monetary terms such as payment of rent or CAM charges. It could also be other obligations or covenants under the lease that are non-monetary. The guarantee acts as a financial safety net for the landlord. It helps cover any missed payments or other lease obligations, as I mentioned earlier. And a guarantor may be a corporation, a bank, an individual with strong credit. These are the common types of guarantors we see executing guarantees on behalf of tenants. What are some key terms of a lease guarantee or terms that should be included in any guarantee? Obviously, first and foremost, there's a promise by the guarantor to perform the tenant's obligations in the event that the tenant cannot or does not. This may include, for example, a liability cap, so potential limit on the guarantor's exposure, an order of pursuit. So oftentimes the guarantees contain provisions that allow a landlord to pursue both the guarantor and the tenant. And oftentimes there is no requirement or a provision should be included in a guarantee that does not require a landlord to first pursue the tenant. A landlord could pursue the guarantor first as well. There are often key terms involving time limits. So how long is the guarantee in effect? How long is the guarantor exposed to potential liability for a tenant's default? There are two common types of guarantees. The first is a full or absolute guarantee. These types of guarantees are favored by landlords because they cover all of the tenant obligations. Again, this could include rent or other non-monetary covenants or obligations. And then there's a limited guarantee, which is favored by tenants. And these are partial guarantees. So they cover, for example, rent only and not other covenants or non-monetary covenants in the lease. They also may expire after a set period. So if you have, for example, a 10-year lease term, maybe the guarantee covers 5 years of that. Another common example we see is with option agreements. So if you have a 5-year lease with a 5-year option, sometimes the guarantees just cover the initial 5-year period and not the option period beyond that. So you'll want to make sure, depending on which side of the fence you're sitting, that you pick the right type of guarantee to suit your need. There are a couple specialized forms of guarantees. One is known as a bad acts guarantee, and this is activated only after specific acts. So, for example, if there's fraud committed by the tenant, or if there is waste or a bankruptcy. So there needs to be a bad act first before the guarantee vests. The second type is a good guy guarantee. And this is where a liability ends if a tenant voluntarily surrenders the premises. So as soon as the tenant gives up premises, that ends the scope of the guarantee as well. There are some common issues that we see with guarantees. Oftentimes, enforceability becomes an issue. It's important that any guarantee be clear and unambiguous. If there are, for example, any conflicting terms in the guarantee, that could create issues and could render parts or all of the guarantee unenforceable or ineffective. Waiver is also a common issue that we see with guarantees. Oftentimes, guarantees include a waiver of rights or defenses. However, such waivers must strictly comply with statute. And if they don't, then the waiver it can result in it being ineffective or unenforceable as well. Deceptions, so guarantees should be transparent and must not be presented in a deceptive or misleading manner. For example, failing to disclose important protections available to the guarantors could be viewed as deceptive and potentially jeopardize the effectiveness of the guarantee. And lastly, consideration is true versus sham guarantees. The guarantor must be a true guarantor. If the guarantor is, for example, a principal obligor disguised as a guarantor, it may be unenforceable as a sham guarantee. So next we'll look at issues from the landlord's perspective and then the tenant's perspective. So from a landlord's perspective, when considering guarantees, uh, landlords should consider the scope of the guarantee. So, for example, does it run for the full term of the lease? Does it expire early? Are there renewal periods? Are there option periods? The landlord should consider a guarantee that gives them the most protection for the longest period of time. Another consideration is a type of guarantee. Does a guarantee accomplish what the landlord needs? Does a guarantee give the landlord that financial stability that tenant alone might not be able to produce or carry out? The guarantor's financial strength. Obviously, if you're entering into a guarantee, there's questions about the tenant's financial strength. So the landlord will want to make sure that the guarantor has satisfactory financial strength to enter into the lease in the first place. Does the guarantor have the financial ability to cover the principal obligor's debt in the event of a default? What assets does the guarantor have? What is the guarantor's liquidity? These are all important questions that a landlord should ask and get additional information on before agreeing to and entering into any guarantee. Enforceability. So as we discussed a little bit earlier, is the guarantee properly drafted? Is it clear and unambiguous? Is it properly executed? Does it contain proper provisions, and are the waiver provisions applicable to statute? Does it cover the full scope of what the landlord needs in terms of protections from the guarantor? All important considerations in putting together any guarantee. Lastly, if a lease is amended, it's important to have the guarantor reaffirm the guarantee. Oftentimes the guarantor is guaranteeing the lease as it is. So any change to the lease, such as through amendment, could create that unclear or ambiguous situation that we would like to avoid. So anytime the lease is amended, supplemented, changed in any way, you'll want to make sure that the guarantor reaffirms the guarantee based on that changed lease. Tenants, when dealing with a guarantee, should consider a few things as well. Again, type of guarantee. Understand the type of guarantee that you're signing and its implications. If it's a full guarantee, then the guarantor needs to understand that they're on the hook for the entire term of the lease. Continuing liability. Does a guarantee unintentionally cover extensions, renewals, or holdover periods? If you are guaranteeing a lease on behalf of a tenant, obviously you'll want to try to limit the time period as much as possible that you as a guarantor might be responsible for a tenant's breach. Modifications. Does the guarantee require the grantor's consent to any change or amendment to the lease? So that's kind of the flip side of what we were discussing before. If you are a guarantor, you want to make sure that there's a provision in there that if the lease is changed or modified in any way, that you both receive notice and have to sign off on a change to the lease as a guarantor as well. And lastly, joint liability. Does a guarantee apply jointly and severally with other guarantors? So this often comes into place when there's multiple guarantors. So if there's more than one guarantor, you want to make sure that you know whether there's a joint and several liability for any potential debt owed by the tenant. Some legal considerations. Guarantees obviously have serious legal and financial implications. You as a guarantor could be responsible for a tenant's default. So it's extremely important that if you are signing a guarantee, You know that the terms that you're signing, and you have a clear understanding of what the implications are should there be a default or a breach of the lease. Both parties should review all terms carefully. If you're a landlord and you're requiring a guarantee, you want to ensure that guarantee covers any potential default and gives you an avenue to pursue being made whole in the event that a tenant who might not have the financial stability in the first place, um, that you have recourse to recover your loss. You'll want to consult with experienced legal counsel before signing to ensure that the specific terms are met and that your goals, depending on whether you're a landlord, tenant, or guarantor, are met through the document. And the goal from everyone's perspective should be to ensure a clarity on scope, duration, and obligations. Everyone should know what they're signing and what the implications are should enforcement of guarantee become necessary. So in summary, lease guarantees are an effective tool to help bridge gaps between or trust gaps between a landlord and a tenant. It provides security for landlords and opportunities for tenants that might not be there, depending on a tenant's financial situation. And every guarantee must be tailored to each situation and reviewed by counsel. Every tenant, every landlord has different needs, and you want to make sure that the guarantee, including the terms and the scope that you are contemplating, meet those needs. Thank you to everyone for tuning in. Obviously, that was a quick review of guarantees. They can be much more nuanced, and a lot more can go into them. So if you ever have any questions about guarantees, whether that be from a landlord perspective, a tenant perspective, or if you're contemplating signing a guarantee, don't hesitate to reach out to us, and we'd be happy to help assist. Thank you.